through. We'll provide an introduction to the Act and start by explaining the nuts and bolts of data protection, outlining why it's important for researchers. My colleague Julie will then pick up on the core topic of notifications under the DPA, covering what it is, why it's important, whether it applies to you, how you go about completing the process, and some general things for you to consider and tips on notification. We'll then conclude the webinar with 5 golden rules for researchers, hopefully condensing some of the wide principles under the Act to some rules that are pertinent for researchers. And in looking at that, we'll cover informed consent in data collection, contracts with suppliers, data retention, the security of data, and making sure that you stay up to date. As Arthur has said, we'll be sure to leave some time at the end of the webinar for any questions that you may have. So stay with us and enjoy. Let's start with an introduction to the Data Protection Act, 1998. The Act actually came into force in October 2001. It covers all data collection and processing methods, including audio, video, computers, computer-assisted telephone interviewing, CCTV, and it sets out a core requirement that you must have a legal basis for processing personal data. Essentially what the Act does is set out the rules to be followed when you're processing information about individuals. And naturally, research is all about data and often personal data, making it very core to what we do. The Act grants rights to individuals in respect of their information and also creates an independent regulatory body, the Information Commissioner's Office, to enforce the rules. It's important to set out some of the key terms and definitions used in the Act to provide a basis for our discussion this morning. And don't be overwhelmed by the amount of data on the screen. I promise you we'll try and stay away from legal terms and phrases following on after this. But first and foremost, what is personal data? This is data relating to a living individual, referred to in the Act as a data subject, who can be identified from those data or from those data together with other information which is in or is likely to be in the possession of the data controller. The data controller is a person who, either alone or jointly in common with other persons, determines the purposes for which and the manner in which personal data are to be processed. And a data processor is any person, other than an employee of the data controller, who processes the data on behalf of the data controller. So why is the definition of data controllers and data processors important? Because it is because under the Data Protection Act, greater obligations are placed on data controllers if there is a data breach. And importantly, and it's key, data controllers must register with the ICO. So, when are you likely to be a data controller or a data processor? We've already highlighted that the key element is determining the purposes for which and the manner in which any personal data are to be processed. In the majority of research scenarios, the researcher will be a data controller, either solely or jointly with another party involved in the research process. So for example, a researcher would be a data controller for research data sets if the personal data is being collected in the name of the researcher, you gather the names of willing research participants through the use of recontact questions, you acquire or purchase a list to use for research purposes, you would also be a data controller in that instance. If data is being collected in the name of the researcher and the client, or another research provider, in that scenario, both parties would be joint data controllers. And of course, a researcher can be contracted explicitly to be the data controller. I think it's important to highlight that the fact that you're providing a service to another organization doesn't necessarily mean that you're acting as a data processor. You can still be a data controller in your own right, and essentially it depends on the degree of control that you exercise over the processing operation. But as a researcher, you would be a data processor if you're providing a service under instruction from the owner of the data, for example, translation services or pure data processing on behalf of another research company. However, if you are the data controller, as is likely in most circumstances, and you use the services of a data processor, you must have a written agreement in place so that whether you're acting as a data controller or a data processor, have some form of written contract. And we'll come back to that later in our presentation. So let's now turn to the data protection principles that the Act is based on. There are 8 principles, but at this point, we'll just focus on the first principle, which is particularly important. This requires that personal data should be processed, must be processed, that is, obtained and subsequently used fairly and lawfully. There are 2 aspects to fairly and lawfully. Firstly, making sure that processing is legitimate by satisfying one of the preconditions. And secondly, by providing individuals with certain specified information when collecting data from them. The key conditions for processing include where the individuals have given their consent. And of course, this is generally the basis for most research, which should be based on the informed consent of individuals. But data can also be lawfully processed where the processing is necessary for the performance of a contract and where it's necessary for the legitimate interests of the data controller. Sensitive personal data is a special category of data. It includes information about race, politics, union membership, religion, or criminal offenses. And if you're processing sensitive personal data, then one or more further preconditions must be met, which essentially means clear and explicit consent. So the Act provides that specified information is to be provided in order for the data to be processed fairly and lawfully. And this includes the identity of the data controller, who you are, the intended uses of the data. You need to be specific about what you're going to use that data for, and any other information that would generally enable the processing of the data to be fair. So from a researcher point of view, the takeaway lesson for the Data Protection Act, and this is underpinned by the conditions and provisions in the MRS Code of Conduct, is that you must ensure transparency in the process so that individuals understand very clearly how their data will be used and securing consent at the time that the data is being collected. So I think that provides a kind of general background to the Data Protection Act and the key principle on which it's based. My colleague Julie will now take you through, I think, what's the nuts and bolts of this session and the practical mechanics about notification under the Act.
Hello there, a new voice here. My name is Julie, and I'll be taking you through the process of notification under the Data Protection Act. This is quite a detailed segment, but hopefully you'll all find it useful. Okay, the Data Protection Act 1998 requires data controllers to register with the Data Protection Regulator, that is, the Information Commissioner's Office, which I will refer to as the ICO during this segment. This registration process is called notification. Currently around 400,000 organisations are registered, and the register is available for public inspection and is fully searchable. Notification is an annual process, and the register changes daily as notifications are updated. The details of a notification can be changed at any time, in addition to the annual renewal. Now, Michelle has already touched on this, but it is important to restate that as a researcher, you can be a data controller across a number of scenarios. One area where there can be confusion is that recruiters and recruitment lists. It should be stressed that in nearly all recruitment scenarios, the recruiter and/or the recruitment company will be a data controller. Sorry, as they determine how the data is collected and used. To reiterate, a researcher, a recruiter could be a data controller if They are creating research participants lists for recruitment purposes, and/or recruiters retaining participant details after a research project is complete for future research recruitment. Do remember that this can be only done with the express permission of the client who paid for the recruitment and the participants whose details are being retained. So now we know what notification is. The next question is, does it apply to you? The ICO has a self-assessment tool to help individuals and companies to determine whether notification is necessary. And the website address for this is now shown on the screen. The self-assessment tool is based on 8 questions, and the answers to these questions determine whether notification is necessary. Okay, so on this slide, you can see the questions and the likely answers were anyone involved in research to answer these questions. Let me elaborate on the answers given on the slide. So let's go through the questions. Question number 1, concerning not-for-profit organisations. Very few researchers are not-for-profits, so the answer here would be no. Question 2 on the slide, concerning judicial functions. This is clearly a no for research purposes. Question 3, concerning personal information. Researchers will nearly always be processing personal information, so the answer to this question would be yes. Remember, personal information is not just obvious things like name, address, national insurance number, etc. It also means data and other information which is in the possession of, or is likely to come into the possession of, the data controller, which together could lead to the identification of an individual. Question 4 on the slide concerns electronic processing. The days of the Rolodex and file cards are long gone, and all research data will be held electronically, even if we're talking about a home computer with an Excel or an address file. So again, the answer to this question is yes. Question 5 concerns responsibility for processing. Nearly all researchers, some, not all of the activities that they engage in, will involve having some control and ownership of data. So again, the answer to this question would be yes. Question 6 regards processing for personal reasons. Research is a business activity, so clearly the answer to this question is no, even though you may well also hold data of this kind. Question 7 regards maintaining a public register. Again, research lists, panels, and so on are gathered for commercial business reasons and not for any public purpose. Therefore, the answer to this question would be no. And finally, question 8. In the context of question 8, the marketing relates to marketing one's services as opposed to shorthand for market research. Again, the vast majority of researchers will process research data, and as a result, the answer to this question would also be no. Okay, so based upon this sequence of answers, the ICO self-assessment tool states that you need to notify. Okay, so now we know what notification is and who has to do it. So how do you go about it? Notification should be completed online, and the web address is on the slide. When you click on this, you will be presented with this image. To notify takes about 15 minutes. You have to register in one session, so you will need to be prepared with all of the relevant information beforehand and be prepared with everything you will need. A small fee is required, so have a credit or debit card to hand. For the vast majority of individuals and organisations that notify, the fee is £35 per annum. Only if you have more than 249 members of staff, note that's staff, not workers, a turnover of over 25.9 million, or are a public authority with 250 or more staff, are the fees higher at £500 per annum. The process requires some details about you and your organisation, including a company house number, if this is applicable, along with your name, address, and details about numbers of staff, if applicable, and the turnover. The rest of the notification process is about what you do with data in terms of the following on the slide here. Nature of work, description of processing, reasons for processing, the type of information that's being processed, about whom information is processed, who the information may be shared with, if it's undertaking research, the use of CCTV or other monitoring, trading and sharing of information, or if the data is to be transferred overseas. Okay, so once you're getting into this level of detail, what should you be thinking about? Here are some tips to help you avoid some of the common mistakes that can be made when completing this process. First up, think about the language you use. Repeatedly, we see notifications which state an organisation does survey research with survey respondents for a survey organisation that surveys individuals. Now, unless your organisation does 100% quantitative research using surveys, this is clearly wrong. Most researchers undertake research with research participants, and they are a research organisation. Next up, be consistent. Lots of research organisations can consist of more than one company as part of its corporate structure. In these cases, consistency is needed between each of the corporate entities. Usually, different individuals will complete the notification for different parts of a corporate structure. And as a result, the notifications for the organisations which make up the group as a whole can become messy, inconsistent, and possibly incorrect. We have seen instances where one part of a group has been notified for research and other aspects not, even though research was undertaken across the whole organisation. Similarly, we have seen very different descriptions being used to describe research activities, which make it hard to determine exactly what an organisation does in terms of its research activity as a whole. If we don't understand it, it is unlikely the regulator will either. Other problems with consistency can also arise within a single notification. So, for example, we have seen research organisations clearly describing what they do as a research business, but within the section for nature of work, fail to mention research at all. So it is also important to ensure that the whole submission makes sense and that it is consistent throughout. Okay, coverage. Coverage tends to be a frequent problem, whereby the current activities are described without scope being given for possible future activities. For instance, this tends to arise with limiting descriptions to describe research activities and current projects being undertaken rather than giving broader descriptions to encompass future likely activities. Specifying selected classes of data, e.g. specific sensitive data categories such as racial and ethnic origin, but not selecting other categories such as religious or other beliefs, or trade union membership, as this is not collected for standard geodemographic classifications. In reality, for research, you never know what you might be asked to collect. Therefore, it is always better to add all the classes of data, as the likelihood is higher that this data will be collected than not. Limiting the list of those who you may share data with, generally listing current customers and suppliers. But again, thought needs to be given to who may possibly ask you for the information. Some of the common omissions that we see are complaints and inquirers. Let's face it, at some time, most businesses face these kind of issues. Trade, employer associations and professional bodies. That does include MRS. This should always be included, as we may need you to submit research information as a result of a complaint or an inquiry. Employees and agents of the data controller, data processors, and also other companies in the same group as the data controller. Another strand that can get excluded is stating the use of monitoring. Usually, this will relate to CCTV, which many businesses will have for security purposes and should be included in their notification. But other points to consider here are whether any staff monitoring is undertaken, for example, such as using recorded mystery shopping to monitor staff. What all this indicates is the need to keep the notification under review to ensure that it remains up to date. Common mistakes here include only reviewing the notification annually when the renewal is due. This is fine if you're a very static business, but for the majority, a more frequent review will be necessary. Having said that, a yearly review is better than none at all. Another common mistake is to allow the renewal to happen automatically without any review of the detail. A slightly different problem can be who does the review. Often the responsibility for notification can rest with an individual who may not necessarily have all the detail to hand about what is being processed. Say, for example, the finance department. The remoteness from the actual day-to-day processing activities can result in a notification that fails to reflect reality. One way to avoid this is to have a small team of relevant departmental individuals from across the business who sanity check the notification to ensure that everything is covered. Finally, our last tip on notification relates to some legacy issues, with parts of the research sector thinking that notification just does not apply to them or that research they are undertaking. Common mistakes include perceptions that they are not data controllers. That is, the data is not held after a project is complete, it does not apply. That is the responsibility of somebody else to notify. Or that a sole trader, it does not apply to them. These are all myths. Think back to the self-assessment activity we did earlier. Clearly, for the vast majority of researchers, notification will apply. A way to avoid mistakes, of course, is to keep up to date. The best places to start are the MRS website, which is a specific data protection advice, and of course the ICO's website, as I've previously mentioned, is where you need to go to notify.
Thanks for that, Julie. That provided us with a really good overview of notification. However, we thought we would broaden this out as the Data Protection Act has a lot wider obligations that are placed on researchers. And it's essential to be aware of and to follow the 8 data protection principles. We've broken these down into 5 golden data rules that researchers should be aware of and that will help you to stay on the right side of data protection law. The first golden rule is informed consent. And this is the basis of the social contract that researchers have with individuals. And that's to ensure that you get the informed consent of participants, be that in face-to-face research, telephone interviews, or if you're using online platforms. The MRS code provides some detailed guidance on what participants should be told. And you need to ensure that participants are always provided with sufficient information to allow informed consent to be given. This includes the name of the organization or individual responsible for data collection, the general subject of the data collection, the purpose, and information such as whether the data collection exercise is going to be recorded and or observed, and who's likely to have access to any live or recorded information. Participants should also be told the likely length in minutes of the data collection if asked, and any costs that may be incurred by them. And that's particularly relevant, I think, in terms of mobile research. Golden rule number 2 is to have written contracts for research projects. The Data Protection Act requires that contracts for processing personal data must be in writing. And this is also reflected in the MRS Code of Conduct. So you must have contracts with all clients and suppliers, setting out clear statements covering your data policies and obligations, and setting parameters on what data you share, for what purpose, and for how long. If you're entering into a contract with a processor, such as for further data analysis or transcription, then you need to tailor the agreement and the technical and organizational measures that you set out in the agreement to the nature and volume of activities performed by the processor. Remember, the Data Protection Act required that the contract provides that the data processor will act only on instructions from the data controller, and that the data processor will comply with security obligations equivalent to those imposed on the data controller itself. So the security measures that you use in terms of how you deal with personal data should be reflected at a sufficiently high standard by anyone who you ask to process data on your behalf. MRS will be developing some template contracts and forms for use by our members that will hopefully help in crafting these kind of documents. And I think it's important to remember that the forthcoming reforms in Europe will maintain the agreement for written contracts in this area and may even go further for additional mandatory clauses. So it's best to get into good practice on this now. Golden rule number 3 is always store and send data to clients or data processors securely. Under the Data Protection Act, you're required to ensure that you take appropriate technical and organizational measures against unauthorized or unlawful processing of personal data, and also against accidental loss or destruction or damage to personal data. The security of the data must be maintained, both in storing your own research data in your files or on home computer or what have you, and also in sending it to clients or to data processors. And you need to put in place sufficiently robust technical security processes in order to comply with the DPA. So in order to do so, even if you're working from a home office, a minimum kind of space, is to ensure that you remember the basics for security, both in your physical environment, in your office space, keeping your laptop secure, ensuring that no one can kind of walk in and just pick it up and take it and the data that's stored on it. And for the computer security, at a minimum, you need to install an antivirus program and update your programs regularly. Secure your laptop as well by encrypting the laptop and having password protection, and making regular backups to ensure data integrity and to avoid data loss. Security also needs to be thought of in terms of how you send your data on personal data to clients. And in doing so, remember, never email spreadsheets of personal data without protection, and send out the password separate from the attachment. Sensitive data can be sent by email. There's no bar to that, but you just need to ensure that you provide a suitable level of encryption. And by encryption, I mean this is like scrambling the contents of the document, often using a password as a key to decipher the contents. But of course, as I said previously, you need to make sure the encryption password is shared securely. Remember that if you're sending audio, video recordings, or transcripts to the clients, all the individuals who were recorded must have consented to this and the subsequent release of this data to any other party, in the knowledge of the purpose for which the recording will be put to by that party. And if an individual withdraws consent after the group or interview takes place, then you as a researcher mustn't pass that data back to the client. And when primary data is released to clients, it must be labeled with the details of the purposes for which it can be used. But of course, you have to take a practical risk assessment approach that considers both the sensitivity of the data and the likely impact of any breach. And data security is measured by the sensitivity of the data that's being processed. So the higher the sensitivity, the higher the security that should be deployed. So you need to assess the risk and respond appropriately, and consider the likely damage or distress that could be caused by a breach. Some categories of data, if released, will be a lot more damaging than others. We had 2 recent breaches that were mentioned in the press recently. One regarding the HIV clinic, disclosing the possible HIV status of people who conducted the clinic, and then another breach of W.H. Smith in terms of addressing for a mailing list. I mean, it's clear to see which of those would be more sensitive and the kind of greater risk that would be inherent in that situation in terms of releasing health data. We recognize that as a small researcher, members of the ICG, that you'll be using off-the-shelf programs, And of course, this could raise issues around the level of control that you have around privacy and possible storage of data in the cloud. For example, the debate around the privacy of data stored under the new Microsoft Windows 10 has been raised with us in light of the fact that the terms and conditions raise possible issues around compliance by researchers with security measures, and possibly also territorial issues in terms of not being certain as to where your data is stored in what part of the computer cloud. So our advice at this point is to use your best endeavors. And perhaps, in terms of when you are setting out your contracts with your clients or you're collecting information from consumers, you can indicate what programs you use for storage so that everyone is aware as to what you're working on. And also ensure that when you install programs like this, that the settings are changed so that the minimum amount of data is automatically forwarded. So privacy by default, rather than going through an express setup, make sure you check the setup to make sure it's privacy enhancing. IT security can be daunting for small businesses, but the ICO has produced a practical guide to IT security, which should be able to help with this. Golden rule 4 is when you're storing data, store it for as short a time period as is necessary. Now, what do we mean by that? How long is a piece of string? Essentially, all identifiable data has to be held securely without any unauthorized access. As if a participant suffers either distress or damage as a result of the data being used inappropriately, the participant can claim for compensation. So it is important for researchers to ensure that records are only stored for as long as needed and deleted in line with a data retention or destruction policy, which you communicate to clients so that they are clear as to the length of time that you will keep the data for. And of course, in terms of how long, the shorter the time period, the better. There's no legal data retention period for research data. And so if there's no set policy in the contract that you have with your client or no requirements from them, our general guidance for research records is to keep primary records for 1 year, secondary records for 2 years. For an ad hoc project, it may be possible to destroy the personal data after 3 months. For participants who are on a panel, then it may be longer. And of course, our 5th golden rule, and perhaps one of the most important, is to stay up to date. It's important to stay up to date. EU data protection reforms will bring about further changes, especially in the obligations that are being placed on researchers and liability with respect to that. So continue to follow the MRS Code of Conduct, regulations, and guidance. The code has legal underpinning, but encourages high standards. There are binding regulations on areas such as non-research projects, incentives, and free prize draws, a guidance document on children's research, which is often quite heavily referenced, and on business research and mystery shopping, and much more. We've produced extensive guidance on data protection, all of which is available to download from the MRS website. There are also some very comprehensive, frequently asked questions, which cover a wide variety of code-related issues, together with comprehensive advice on how data protection affects research. You can always seek advice from our MRS Code Line service if you have queries about notification, or indeed any other data protection or code-related query. The service is a member benefit, but we do provide some general guidance for non-members. The details for Code Line are on the slide, and remember, it's always better to check and get it right than leave it and be wrong. And of course, our website, as I mentioned, will provide information updates, and we'll be providing new guidance once the implications of the EU data protection reforms are much clearer. So to conclude, a reminder, why should you comply with the ICO? Well, because breaches of the Data Protection Act cost time and money and can damage your professional reputation. Failure to notify is a criminal offence and can lead to a fine of up to £5,000 in a magistrate's court or unlimited fines in a Crown Court. And I've listed several examples on the slide. A Cardiff-based green energy deal company was prosecuted by the ICO for failing to notify that it handled personal data. The result? The director was fined £270 and ordered to pay £300 prosecution costs and a victim surcharge of £27. The same penalty was applied to the business. Another example was the Payday Loans Company. The director was fined, ordered to pay over £1,000 towards prosecution costs, as well as a victim surcharge, along with the organisation. And of course, membership of an accredited association, which is a requirement for some clients who use researchers, may be in jeopardy if you breach the Data Protection Act. So that's it. I believe we hopefully have some questions waiting, and Julie and I are quite happy to start answering those.
Thank you, Michelle and Julie. I'm just going to change the screen over, and then we'll get into some questions. So I do have a couple of questions already. Let me just share those with you. I think the first one was from Luca Meyer. Luca is based in Italy, I believe. And his question is, do only UK-based companies need to notify, or also companies based abroad?
Well, I think that would depend on what data you're processing. So if you're processing the personal data of participants who are based in the UK, then you'd certainly need to register with the ICO.
Okay. Here's a question from Liz Montgomery. Hi, Liz. Really interesting session. Absolutely, I'll agree with that. Especially the section about keeping on notifications up to date and under review. As small, typically one-person businesses like us, what is the best way for us to sanity check our notifications? We don't have the luxury of dedicated staff or departments to work on this.
Okay, well, I would advise, Liz, that you make the good use of the ICO's website and the advice that is given therein. Going back to the self-assessment tool, which I mentioned during the presentation, that's very, very helpful. Also, the ICO is able to answer questions regarding what actually requires assessment. And as far as we're concerned at the MRS here, we're also happy to help members with any assessment questions that they have as well.
Okay. We've got a question from Sarah Jane Miller. She says, through notifying ICG, I think she probably means ICO, what does an organisation receive? Any further guidance or accreditation? Show they advertise being accredited like you would with the MRS Code of Conduct. Maybe she does mean ICG. Sarah Jane, I'm sorry, I'm just slightly confused about the question. Perhaps you could have it is ICO, okay. She just come along and said, so through notifying ICO, first of all, what does an organisation receive? Can we answer that?
Well, you have a number which you can then, well, Arthur, you're probably better to kind of indicate what actual document you get and how that proceeds. But I think the essential point is that you will have a number, and people will be able to therefore check that you're registered, either by using the number or by just searching with your company name, so it can be validated.
That's right, yeah.
The public registers, therefore, to be able to access quite transparently, so that it can always be verified whether or not you're registered.
Absolutely. A good example to use would be like Companies House. You know, if you want to see if a company is registered, then obviously there are publicly available lists, and they are actually given a registration number. So the same does apply to the ICO registration.
Well, as it happens, and I mentioned this to Michelle and Julia earlier on when we started our conversation, today I received a letter from the Information Commissioner's Office, which was a notification of my renewal being due. And I get mine renewed on a direct debit basis, so I don't have to remember to renew. There's a direct debit system. The organisation name is me, so I am the data controller, I am the organisation. And I have a reference number as well that you were referring to. and all it does, it tells me that they'll connect the renewal fee. I seem to remember when I first registered, maybe I got a certificate or something. I can't remember, and it may well be filed away. But certainly what you do get, Sarah Jane, is a number. Okay, I hope that answers your question. So we have another question coming in from Nanda Marchant. Thanks. You alluded to there being some templates regarding data policies. Are these available? And if so, where do we find them?
We're currently developing them, so they're not available as yet. But when MRS, where we did our road shows, a number of members indicated that this area, in terms of contracts, can be quite tricky, and it would be useful if there were some clauses that people could look at. So that will be placed in the MRS members area for access. I don't want to kind of commit myself too tightly, but I should certainly say, by the end of the year, as a kind of Christmas gift, we'd hope to have that ready and available.
Oh, we can't wait. Thank you. Now, when we advertised and promoted this particular webinar, we know from the last member survey we did that about 20% of our members are registered with the ICO when we asked the question. Clearly, I think that's more need to be registered. And in actual fact, I would probably say that all ICG members would need to be registered. If you are a researcher doing quant, qual, whatever you're doing, are there any situations where registration or notification is not a requirement? Can you think of any situations where a market researcher would not need to notify the ICO?
I would say that was highly unlikely, Arthur. I think, the advice that we would give at Codeline to members would be to always notify, because there is always the chance that you could stray into the notification zone, if you like. Projects change, things change. Our advice is to look after and support our membership, and bearing that in mind, we would always think the advice that I would always give would be that it is always best to notify, because then you are covered for whatever project or whatever work you do. Then there is that coverage for you.
Some members might think that they haven't registered. Maybe they didn't realise they needed to, and hence us doing this particular webinar today. So I hope that those people who are not registered have got sufficient information to be able to decide whether they should notify. Are there any links between notification and the MRS code? So in other words, if you are an MRS member, does that almost require you to notify?
The first rule of the code states that members must ensure that research conforms to national and international legislation relevant to a given project, including the Data Protection Act 1998 or other comparable legislation. So that is a requirement, and of course it is a requirement to register if one is handling data in that way. So yes, it does directly tie into the code of conduct.
Because as you were aware, when you become an ICG member, you don't have to be a member of the MRS. But you do have to agree to abide by the code. That is one of the things that all ICG members have to commit to. They have to abide by the code, even if they're not an MRS member. If you then take that to its ultimate conclusion, you could say that if you're an ICG member, by definition, if you're following the code, you should be registered. You should have this notification. Would you agree with that?
I would, yes.
Yeah, I certainly would agree, but I think we can always go back to first principles, which is you must be legal, and the consequences of not registering are, disproportionately high compared to the cost of a £35 fee. And the process, as we've outlined, is quite simple, so that, in terms of priorities for your business and any kind of due diligence check, it would have to be need to follow the act because it's a legal requirement. Consequences of the breach are too great. I compromise any membership of MRS, similarly ICG. So I'm I'm going at risk of breaching not only my legal obligations, but my professional and regulatory environment as well.
Okay, I'm going to push it to the final point here. Let's say that you are made aware that somebody who should be registered, and it's clear that they should be registered, is not registered, and they are an MRS member. What action would you take?
We would speak to the member.
Yeah, we would have to take that up with. Yeah, we would have to. I mean, I think probably the best approach would be for us to have a dialogue with that member and explain the importance of their adherence to the code to be legal, as Michelle's just highlighted, and that they must register.
And if they say, "I'm not going to," you presumably the endpoint is you just kick them out of membership.
Well, there would be, well, not necessarily. I mean, there are various
due processes
and sanctions with regards to breaches of the code, but quite clearly we would then be presented with a breach of the first rule of the code. So that would have to be looked at quite seriously, certainly.
Hmm. And there's just been a note in from Judy Williams. Hi, Judy. It said, just to clarify on my question, are there any circumstances under which a market researcher does not need to be registered? I think what you're saying is no. Is that right?
Well, I think if a person is in the position of where they are, I mean, I can't think of many circumstances where a researcher would not be handling or storing or passing on or have some responsibility for identifiable participant data. So in that case, we would always recommend notification. I guess if a researcher was not having, in some way, was not having any identifiable participant data, so no identifiable data as it is described under the Data Protection Act, then maybe that would be so. But in every other case, if they are actually handling identifiable participant data, then they must be registered.
Yes.
And I think to add to that, as a market researcher, you would naturally, as part of your professional skills, be advising a client as to how the research is structured and conducted. So you have some kind of input and intellectual say. So there's some kind of level of ownership of that. You're not simply taking instructions and doing exactly, you're feeding in. It's a two-way process. So that places more responsibilities on you in terms of being a joint data controller. You may not be a sole data controller, but certainly you'd be involved in determining the purposes and the manner in which this data is going to be processed. That's kind of part of your professional judgment in your toolkit. So that if you're just simply, transcribing interviews and you're just processing data in that respect, then maybe, but I would expect that members of the ICG would be involved in this kind of intellectual exercise where you're providing input and advice on how the research is conducted.
So at the minimum level, if I'm a qualitative researcher, I don't do any quant research, I'm a qualitative researcher and I'm doing some depth interviews, and I have a recruiter who supplies me with the details of the interviews that I've got to go and do, that is personal data. That is the sort of data that needs to be notified. So even if you're only doing, to be extreme, you're only doing one interview in a year, but you're still being informed about that electronically by a recruiter, you need to notify.
Yes, because the participant names would be on that electronic file, and they would need to be stored and processed in some way. So yes, there would be a requirement to notify.
Okay. Luca Mayer has just come back with a follow-on question from his notification. Remember, he's in Italy. He says if he recruits foreign participants for a UK agency, would he need to register? So he's working for a UK agency who presumably would need to be registered.
The agency would need to be registered, yes.
Would he, based in Italy, recruiting people in Italy for a UK agency, would that require him to be registered or not?
Possibly not. I mean, I think in that case, it may be that Luca would need to register with the local association or, the government, whatever is responsible for data protection in Italy, if that's where the participants are actually based.
So maybe an Italian version of the same thing, which he needs to be aware of, I guess.
That's right, yes.
Okay. Right, I've got quite a few more questions. Midge, Welcome, Midge, new chairman. Well done. Midge asks, could you clarify the password protection and encryption requirements when emailing Excel sheets containing personal data? Do you need to do both, or is password protection sufficient?
Password protection would be sufficient, and just ensuring that you send the password separately. If it's very sensitive data, then you might want to go a step further and encrypt. You essentially assess the kind of sensitivity of the data and decide what step you think is appropriate for that.
Okay, but as a minimum, it should be password protected.
Yes.
Yes.
Okay. So I've got another question from Sarah Jane, who says, presumably all research agency suppliers, for example, data processors, panel providers, and qual recruiters, should also notify the ICO.
Not in every case. I think this is. I think it's. I mean, we would. Our advice is to our membership is that they really should notify, to cover them for all eventuality. Now, there are so many nuances, if you like, with regards to notification. It's probably best, again, if the self-assessment tool is used on the ICO's website, if anyone is concerned about it, we would give advice to say, look, you really should be doing this because you're covering yourself, you're covering your clients, you're covering the participants, and you're giving that level of reassurance and security by notifying. But if any particular individual is concerned that this possibly would not apply to them and they don't want to pay the notification fee, that's fine. But I would strongly advise that they use the self-assessment tool on the ICO's website so that they can see if this absolutely applies to them.
Okay, and Liz Montgomery's come back with perhaps a clarification on this, suggesting that the only researchers who are likely to be exempt is those who only do desk research.
By that, would you mean that there's no processing of any identifiable participant data?
Right. I mean, maybe what they're looking for is just published data, published reports, and synthesizing that into a report back to their client, where they are never dealing with, if you like, primary research, where they're getting involved in, talking to individuals or whatever. So that could, yeah. I don't think
so they're not handling identifiable data then? There's no identifiable participant data there?
That's correct, yeah.
Well, in that case, no, they would not need to notify.
Okay. Well, look, unless anyone else has any more questions, I think we've come to the end of that. So some really challenging questions there, and thanks for all those great answers.